Mr. Chair, Mr. Deputy Chair, Honourable Senators, thank you for inviting me to address you today on the subject of Bill C-42, the Common Sense Firearms Licensing Act. I am pleased to testify in support of this legislation and to highlight the importance of its provisions to law-abiding gun owners in Canada. I also want to clarify and preempt some of the criticisms of this bill, criticisms that, in my opinion, are based on fundamental misunderstandings about the way firearms are used, transported, and regulated under the Firearms Act and the Criminal Code. This bill is important in several respects. First of all, it blunts, to some degree at least, the criminal consequences for law-abiding citizens whose only crime is to fall behind, inadvertently or otherwise, on matters of administrative paperwork. Recall that as of the introduction of the Firearms Act in 1995, the mere peaceable possession of a firearm, no criminal intent or act required, became a criminal offense, unless the individual held a valid firearms license. This was no mere tinkering. It was a sea change which transformed millions of Canadians overnight into presumptive criminals. In other words, instead of the scalpel of social policy and regulation, Parliament used the sledgehammer of the criminal law. Those who failed to comply, even with the most minute detail of the overall scheme, faced criminal consequences, including arrest, detention, and imprisonment. Clauses 14 and 16 of this bill would give licensed firearm owners a 6-month grace period, during which they cannot be subject to criminal liability under Section 91 of the Code, in order to return to compliance with the law. This provision recognizes the reality of firearms ownership and the long-standing criminal law principle that individuals should not be subject to criminal liability for inadvertent or unintentional actions. It distinguishes between the truly criminal use of firearms and the type of conduct which the Supreme Court of Canada has described as a licensing infraction, which carries, quote, minimal blameworthiness. Once this bill becomes law, some 2 million licensed gun owners can rest easier, knowing that they will not become paperwork criminals overnight, simply for inadvertently failing to renew their licenses. In addition, this bill addresses the transportation of restricted and certain prohibited firearms. Specifically, it requires that an authorization to transport be issued as a condition to a firearms license. Until now, the provincial chief firearms officers, through their issuance of authorizations to transport, added an unnecessary and burdensome layer of red tape while providing no further safeguards or oversight. Bill C-42 would simplify and centralize this process. Moreover, this makes a great deal of common sense and is in fact faithful to the intent of the Firearms Act as originally drafted. In fact, Section 61 sub 3 of the Firearms Act explicitly states that, quote, an authorization to transport may take the form of a condition attached to a license. As my co-authors and I note in the Annotated Firearms Act 2013, to date, authorizations to transport have not, in practice, been attached as license conditions. However, there are no valid public policy or safety reasons why this has not occurred. Now, there are those who have claimed the Bill C-42 would somehow relax the laws and regulations governing the transportation of restricted firearms. This is absolutely false, and I would urge you to reject such suggestions. The Senate of Canada is the home of sober second thought, not irresponsible fear-mongering. Let me be perfectly clear. First of all, the manner of transportation would continue to be dictated by the applicable regulations. Nothing in C-42 amends that. Second of all, the places to and from which restricted firearms could be transported are the very same places that were previously authorized by the chief firearms officers in their standalone authorizations. Thirdly, the current requirement that all transportation of restricted firearms be, quote, reasonably direct is in no way affected by this legislation. I would like to conclude with an observation. This bill is an important step forward in the fair treatment of gun owners in this country, but it is only one step along that road.
And we'll move on to our next presenter, Mr. Brown.